Here's one AI application that could benefit in the future. Mics that can actually turn on by themselves when needed.
Hello everybody. I'm Irfan Murthy. I'm a senior IP attorney at IBM. At IBM India, I manage all IP related issues and including patents, trademarks, copyrights and litigations.
Hello, my name is Georg. I come from the European Patent Office from its branch in Munich, whereas Surface now as a director of an area in ICT for no more than 30 years, and artificial intelligence is for sure a very interesting topic on many aspects in patenting areas. Thank you.
Good afternoon, everyone. I am Collin I represent IEEE. People who are not very familiar with IEEE, we are the largest technical professional association, and we exist with a mission to advance technology for humanity. And we do that by publishing, organizing conferences, setting up technical standards, and being in this domain, we are at the forefront of artificial intelligence and fourth industrial revolution.
Hi. Hi, good afternoon. My name is SK Murthy. I am the parent counsel for Intel in India. I have been with Intel for a little more than 14 years. And my total experience in IP is around 17 years. Thank you.
Hi, I'm Jitin Talwar. I represent XLPAT and TT Consultants and Talwar Advocates. I'm a patent attorney in India and patent agent. Also, along the lines we founded this due diligence company called TT Consultants. All my life I've been probably running away from stuff which is commoditized. So we saw about 500 companies prop up. So then we went into AI and machine learning and innovation. So that's what is driving the intent and growth and R&D right now. We're doing some stuff which is very interesting. I'd like to present that today. And along the lines, how the impact AI is impacting practice of law and issues that come up, I'd like to present those. Thanks.
And I'm Andre Frieden, Chief IP Counsel for Wipro, and Wipro is very excited about AI as well. And we already have one platform called Holmes that has already been quite a success in the market. So before we jump into IP, I want to first get some of the nomenclature well understood about what AI is. So what is AI? And what are some of the subsets of AI so that we understand the differences in terminology? Perhaps, Irfan, you can give us your view of what AI is to you.
Artificial intelligence is an umbrella term, for a simulation of artificial intelligence by computers, by machines in general and computers in particular. As I said, it's an umbrella term. So you have machine learning. Within machine learning, you have deep learning. Typically, I think everybody is aware, the term artificial intelligence is itself self-sufficient to define it. Beyond that, should I throw some light or we?
Yeah, maybe also talk about neural networks and how that augments the value of AI systems.
That would be, how can I define neural network? How do I create possibilities and answer to those possibilities is what neural networks do. Let's give you an example. IBM in 2016 had created an artificial intelligence movie trailer. If you go to YouTube and check Morgan, this was a movie which was about to come out. The producers reached out to IBM and they said that we want to create a movie trailer using your software. Now typically if you want to create a movie trailer, you have to use your subjective skills, without giving away the plot. So you will have to watch the whole movie You will have to select scenes from them which will excite you, which will invite you to go and watch the movie, but yet not give away the plot. So how can a machine do that? So a neural network is something, what enables you to do that, it takes up lots of data. You train the data and you give out an output. So whenever you have time, there is a whole documentary on how that movie trailer was created. So that is one of the use cases of AI using neural network.
Artificial intelligence itself refers to a direction when machines start developing cognitive skills like human beings, right? And when it comes to artificial intelligence, as Irfan said, there are several layers: machine learning, deep learning. And if you look at a very broad level, if you look at the techniques used for machine learning would be statistical methods. Whereas when it comes to deep learning, we use neural networks. And neural network is very similar to how a human body or functioning of a human body happens, right? There are several neurons get connected to each other through synapse. There is a lot of backward and forward motion of data. There is no particular direction in which the data flows. The data can flow backwards, forwards, all those things. But most of the systems that we have, the hardware systems or the software systems, the data flows in a particular direction, right? There could be, it started with sequential, then it started with parallel, but all of these things are so very well organized in one direction. But whereas the human body, the neural networks or the neuron distribution of the neurons and the sharing of information in the body is not in one particular direction, or not. It is not like okay, there are 4 paths or 4 data pipes. It is completely a mesh kind of system, and neurons have minute computing capabilities. So for deep learning, we use neural networks which has started mimicking how the neurons work. That's why the name neural networks. And if you look at deep learning, which is based on neural networks mostly, there is huge amounts of data that is fed into the system as compared to machine learning systems, machine learning algorithms. They handle smaller amount of data. It is mostly non-video or non-graphics based data. So neural networks probably would use huge amounts of data, especially graphics, video, those things. I'll pause here and see.
Yeah, we'll cover the intense use of data when we'll talk about monetization, commercialization of this technology. So again, right before we still get into IP, given the importance of this technology and its promises of the future, how do you see the competitive landscape in AI? Will it be dominated by the big players of today, like you have seen in the telecom industry, or will you start seeing flourishing community of new players globally in this technology? So do you foresee a very competitive field, or the opposite, a dominance by big players? Maybe Jitin, you can start.
And as somebody who's always both working with and working against lots of big companies from time to time, what I can say is there will be both. There will be dominance of big players, but there will be lots and lots of niche players in the field with very interesting niche applications. And eventually, somebody will grow. The obvious advantage that folks will have, the bigger folks, is this incredible amounts of data that they already will own. It's almost like huge. I mean, like, look at this 10-year challenge which is going around these days. Essentially, what this is going is enriching Facebook with this 10-year aging kind of in inputs to the machine. The amount of data that Google has, the amount of data that Apple ends up having, this will essentially make them those superpowers. However, there will be really innovative applications that will eventually end up generating. So there will be all of the above.
Anyone else?
AI is a very highly published field, and statistically speaking, what we've seen that while the established companies continue to, be present in this domain, but interestingly, what I find is the academia is doing a lot in this area, as well as smaller corporations, startups are doing a lot. So I think, there will be technologies that, the established players will continue to advance, but the new technologies or, some disruptive things will come from startups is what I see.
Mm-hmm. Okay, so from a perspective of protecting the IP embedded in AI innovation, patents are not the only way to protect. So what I'd like to hear from this panel is not only the patent protection, but how do you advise your businesses? How do you advise in terms of the holistic protection that you're looking for in your innovation in AI? So maybe Irfan, you can start with that.
Now we face this question. Quite often. Patents is a standard protection that whenever you come up with an invention, you apply for a patent, and IBM being IBM, and we file so many patent applications, that's a given. But what else? Now, that's where we are stuck at. And copyright, of course, is one of the major things. But the problem with copyright is that most artificial intelligence or machine learning models, when they are actually created in the source code, they are in interpreted language form, right? For example, Python, and they are not compiled. Now when they are not compiled, and if your model of licensing these AI's products is not cloud-based, wherein the client would have direct access, and if it's distribution-based, which essentially means that they have access to the source code. So although they will not what they can do is, they can get a concept out of that source code. Once you have a look at the source code, you get a concept that, okay, this is how the mathematical model is created, and that can eventually lead to smart infringement, which will eventually not be copyright infringement. So, that is a question which keeps bothering we IP lawyers most often, and the only answer to that is how can we write models which are, in languages which are compiled. For example, you can even, Scala, I believe, I'm not sure if Scala can be compiled, but Python, I believe, can be compiled, although most often it is not compiled. But then, that is the first fallback scenario. But beyond that, I believe that, one should look at trade secret as one of the options, or else contractually get into a situation wherein, put a watertight contract saying that even if you have access, the residual should be toned down a little bit, to protect from that smart infringement. But the traditional avenues are patent, copyrights, and trade secrets. I believe, databases wouldn't be of much help, but eventually I foresee that 5 to 7 years down the line, for a country to really progress in AI, some sort of answer will be required to those questions as to how exactly to deal with this scenario wherein most AIs are written in interpreted language, and how best to prevent giving away access to the source code if the product is done in a distributed manner and if it's not cloud-based.
Mm-hmm. SK, how do you advise your business?
Even before looking at what are the ways of protecting the IP in AI, probably it would make sense to take a step back and see what an AI system would look like. Once we know what an AI system would look like, then we can tailor the IP protection solutions to it. So if I can lay out a AI system, if I take a box, this box could include hardware, especially designed to handle AI workloads, and we could have machine learning algorithms, deep learning algorithms on top of it. And for all these things to work, there should be data which should be provided as an input to the system. So if you look at the hardware system itself, where it has to handle lots of workloads, then there could be lots of innovation in the hardware. So those innovations could be protected by patents, right? And if we move one level above, there could be virtualization, right? Virtualization can once again be protected by patents. And then we can also have, slowly as we move upwards, then some of the expressions of machine learning algorithms, some of the expressions of deep learning algorithms can be protected by copyrights. And if it is done on an open platform, open source platform, then we have this GPL, LGPL, all these licenses coming into play. All these things are already known to us, right? One thing that is new to the world is the data protection laws. Because data is one of the integral parts of an AI system. So how do we protect data? Data can be protected through internal protection mechanisms like information classification, identifying or labeling the information as, for example, top secret data, and then classifying them as personal data, orange cover data. So classification of data and how we protect data, would it be by trade secrets? All those things become important. So we need to look at each of these components and then apply what is the best suited form of IP to protect all these things.
Mm-hmm. So then when we look at patent protection, maybe a good starting point is, let's see what the European Patent Office, first of all, how you define AI and how you see the world of AI, and then sort of where things have gone in development of portfolios through the EPO.
AI is for us just a word, as many words in the world exist, and there is apparently no internationally or commonly agreed definition what is AI and what is not AI. It would also not help a patent office in its process, because we look all at the time of filing a patent application what was meant by the inventor and the applicant. Whether he calls that AI, machine learning or something else doesn't play a fundamental role, because one thing is clear: when we talk about something which is AI, we may need something like a computer. And as soon as we have something like a computer, we talk about computer-implemented inventions. And then we are in the classical area of computer-implemented inventions, and where the EPO has a well-established practice of examining such an invention, which the key element is our two-hurdle approach. The first hurdle, it must be somehow technical. It is technical as soon as you use a computer, or it is computer implemented. That would be the basic enough. But then the second hurdle is, as for every invention, it must involve an inventive step. And involving an inventive step, it must be novel, and second, contribute to the solution of a technical problem. So then the question will be, to what extent whatever you call AI contributes to the solution of a technical problem. And if this AI does not contribute to the solution of a technical problem, then it won't be inventive. Technical, but not inventive. On the other hand, if it does contribute to the solution of a technical problem, then it will be treated as any other normal application for a patent. Basically, that's how.
What are some of the recent trends in EPO on AI applications? Have you seen a dramatic growth?
Yeah. First, what I said before about the definition story, it is not quite easy to make a statistic out of it, because many applicants simply don't call it artificial intelligence. They describe what they do. So we have first to figure out, is it something which would fall under the definition of AI? We have made some statistics by taking due care to cover most, but not too many of the computer-implemented inventions with AI aspects. When we go to AI, more on the core technology, we had 2 or 3 years ago, we had about 10 or 15 patent applications. Now we have about 800, 900, so there is an exponential increase of the use of AI. This can be explained two sides. One thing is, of course, it is booming. This I don't need to tell you. Everybody is working on AI and is using AI solutions. Therefore, also patent applications with AI increase. Clear enough. On the other hand, also, of course, because everybody talks about AI, everybody tries to write in his patent application also an aspect about artificial intelligence. So it might be we have a very normal computer implemented invention, but AI is mentioned in. So this to a certain way has to be a little care about when you look at statistics. But that's something normal, this you have with blockchain. Since everybody talks about blockchain, you find in every patent application more or less blockchain where it could fit in. Similar is it with AI. But one thing is clear, there is a trend, an increasing trend. There will, what has been before said, what we observed, there are the old classical players, of course. There are a lot of new players. The new players in this area can be small startup companies or smaller companies, but also large companies from other technical area. We're talking about chemistry, automotive industry, medical, and pharmaceutical industry. They also discovered that probably we have to do something in that area. So what we see is globally competition in the patent battle is increasing on these fields. Mm-hmm.
Just to add from the statistics side is that in general, in the last 1 year across all patent offices, there are more than 10,000 applications in artificial intelligence, patents in artificial intelligence. And if you look at the high-level areas, I think it's driven by machine learning, knowledge representation, and computational system based on computational and biological models. So these are the top 3 areas in which most of the patenting activity is occurring, across the world.
Also, fundamentally AI is not new. It has been there since 50, 55, 60 years, 1960s, right? So most of the fundamental concepts are already in the public domain. How we use them and how we improve them is probably one area where we see a lot of IP getting generated, and on top of it there are several use cases that are being developed. So we may see a lot of IP developed in those areas rather than fundamental technology itself, and there could be a lot of prior art out there already on AI.
Just to second Murthy's point, when I did a search in our platform, my platform, the earliest article I got from was 1910 on artificial intelligence.
And that's certainly. SK, also, how do you advise, or what are some of the challenges that you see on patentability, and what are the type of advice that you give both to your inventors and to your teams as you start drafting these applications?
When it comes to patentability advice, the standards are already set. I don't see there is a huge deviation on application of these set criteria for AI applications, right? It is the same novelty, utility, and non-obviousness, and just because it is on an AI system, the criteria does not change. It is the same criteria, right? So from that perspective, it is not hugely different. In my mind, it is not hugely different. Though the impact is huge, the markets could be huge, the people who would get benefited by this would be huge. From a patentability perspective, I don't think there is a much difference in what we are seeing, right? And probably the second thing that I see is the ownership issues. There is a huge debate on ownership issue. So if I go back to my example of this box, we have machine learning algorithms, deep learning algorithms, hardware, and the input is data, right? So when we give this particular data to this ML or DL algorithms which work on this particular platform, we expect a certain output, right? So if it stops there, or if that is the only domain that we are dealing with, then IP issues and ownership issues are very clear. But one thing that can happen is, inside this box, I have provided a machine learning algorithm or a deep learning algorithm, and my hardware is known, the platform is known, but these machine itself can learn something and it can become new, and once the data is provided to this machine, instead of getting X as an output, which was expected, probably I get X and also Y. Who generated Y is a question. So if it is a machine which generated Y, based on what? Did it invent something new? And who should be the owner of such inventions is something that is broadly discussed, widely discussed. But if you look at most of our patent laws, it says it should be a person. So from that perspective, at this point in time, we are probably clear that these machines will not get authorship or inventorship, at least at this point.
And George, we chatted earlier about what if there's a non-human inventor? So how does the law work in Europe?
At present, there's a very easy and bureaucratic answer to it. You have at the EPO and at most patent offices, you have to designate an inventor, which must be a human being and a real person. And if you're not going to do that, you simply don't pass the administrative hurdle of getting a patent application filed. Therefore, the issue for a patent office is solved. So when you file a patent application and saying my artificial intelligence called X by Z number so-and-so has invented the following, we will not accept it because it's not an inventor. End of the story, and there will be no debate if a machine can be an inventor. Legally speaking, is what we see, and if you see the evolution, development of artificial intelligence, it is no more or no less than a machine. It's a more clever computer with a clever program on it. Excel, for example, is also artificial intelligence or not. You can sort, you can order according to numbers. So it's just another step more. So we say it's a complex machine. Now, using a complex machine does not prevent you to get a patent. Let's say you have a complex mixer of mixing together the ingredients for a nice cake. You may get a patent for the cake without needing to fully understand the technique of the mixer. I see the same thing with artificial intelligence. If the invention lies in the use for a certain technical purpose of artificial intelligence and you get the solution of a technical problem, well, it doesn't matter what the contribution of the black box artificial intelligence is. There is a contribution on it. On the other hand, if you improve the black box or the machine as such, and that is sometimes where we see the problem in patenting, is that the necessary details which contribute to the solution of a technical problem are not given, and then you might have an invention, but you have not sufficiently disclosed it, and so you don't get a patent. But for the time being, we would say, well, the person who files the patent application or the company who's doing that gets the right for the patent, and they have the obligation to designate the proper inventor or the team of inventors, and I would say at the very end it will be the person who operates the machine in a successful way.
Jitin.
Yeah, so we were just having this discussion just before the session again, that technology has always been ahead of law, always. However, with the speed at which technology is progressing, law needs to really take shape. I will be I'll just be showcasing a screenshot of how, in a possible scenario, in a client counseling session, during practice of law, an attorney could be in a situation where the inventorship could validly be of the machine, or at least the suggestion in first cases would be machine. It's not Star Wars material, but it's a first step towards how machine could possibly be an inventor. However, coming back to how you draft a claim, here are some of things that that we've seen, or at least have seen having, is at least when you're as you know that AI has been around for so many years, the technologies has been around. However, the data inputs that are coming in is a big factor. Also, what you need to also take care of is, in not very in a few probably months from now or years from now, by the time the patent application is published, you might have 5G, you might have IoT, which is, in any case, IoT is already there. Do you have distributed computing with 5G? Do you have blockchain applications with that? So do you mention, at least in both in the description as well as have some basic claims where there is a mention of these future technologies which could be implemented along with whatever the base technology that is being implemented. That's something that, as during regular practice of law, one needs to keep in mind. Also, what's also happening is all these, especially if it's a large or largish portfolio, you'll not be able to stop the end customer from being able to use any product. So, for example, company A will not really go after the users of company B because they all want to be nice these days. However, we've seen more and more of these claims being directed against intermediaries, those mid-sized companies where it's a security system, or it's a data integration system, or there is an actual use case applied onto a camera vision use case or whatever. So what we've seen more and more is claims which are being directed towards intermediaries and not the end user. So that could be that's another factor which we've seen in applications which have been drafted in specifically this field.
Mm-hmm. And do you want to go through your slide now?
Yeah, sure. So if it's the right time, I'll go through my slides. So what I wanted to pursue was it's a related topic that relates to a very important question during practice of law, especially, or in inventor counseling that one comes through. Essentially, the idea is that when you're already coming up with technology, when there is this all this talk about artificial intelligence and machine learning and all that, how is it actually impacting the field of AI? And this is how it is. Next slide, please. I'll just go through three different ways in which we've seen. This is the traditional route that you're seeing in front of you. A large company, typical scenario, patent review committee. The patent review committee takes about 3 to 5 months overall. The process, your patent system, your innovations go through a proper process. That proper process has a search and analysis part. There is assessment. There is drafting. This is the typical piece that goes forward. However, once you're using next slide. Once you're using a more modern way, using a system at least, or a system, or a process where at least every person within an organization is able to actually use natural language based systems. They're also able to use vision based analysis. They don't need to go to the typical IP department or an IP review committee. The set of systems are actually taught to the machine. The AI is taught those systems, and the client counseling really gets inverted on its head. The practice of law, client counseling really gets inverted on its head. So essentially, that bit where either the attorney or the IP department or the head of the R&D comes in contact with the actual inventor, or in an alternate scenario, the inventor himself is able to go through with the system and go through these sets of rules and rules that are fed into the system, is when you're able to then bring regular innovations faster to the market and actually effectively utilize AI to bring a difference or to bring along a difference on the ground. So we've used this, this is personal experience, we've used this in companies where during the process of inventor counseling, tools that have AI implementation have been used, and what you realized is for large companies or mid-sized companies to be able to bring inventions to fruition much faster. Secondly, what I say is every person in every company as a result of AI will be able to convert their ideas to innovation and innovation to IP. So what does that mean? The idea can come, take for example a company like say an Amazon or a DHL or a FedEx. The idea can come from the driver to the CEO. Everybody can have an idea. How does a company really take those ideas which are coming to folks at the bottom of the pyramid? They take into account. So again, if you're able to reach out, democratize data, which is being done, and you're able to democratize the process of innovation counseling, and you're able to also train your people, train the systems much better as compared to just training the people. You've got to also train the people. You're able to bring in innovations faster to the market. The other point that I was talking about just now was, next slide please, was what happens, next slide, what happens when, this is helpful. Came a slide too late. So what happens, there's just concepts that go on, but this is what I wanted to say, is this is a typical system that I just, it's a screenshot of a typical system that I just put in, is that, there have been these TRIZ systems, TRIZ related concepts, there have been these white space related concepts, which has always been out there. Now, these are algorithms that work on essential machine learning, traditional machine learning algorithms. Now, if you end up teaching them to the machine, what you say is that machine ends up suggesting to you newer ideas, right? And on the left, what you see is essentially what you entered into the system, and on the right, what you say is application of what you entered into the system as applied differently and not applied within the systems that you entered in, right? So this is a typical example of how possibly a machine could lead to ideation and machine learning could lead to ideation. So that's what I wanted to point out. Happy to take questions and continue the discussion.
Let's focus now for a moment on building the portfolio. What are some of the challenges you see in working with your R&D teams, the business teams, in fully exploiting AI's potential through the patent process and building that portfolio? What are some of the sort of overarching advice that you give? Maybe SK, you can.
Yeah, when it comes to building portfolio for AI, the first thing that I would think is, because of the application of AI to various fields, I would have a portfolio focused on some of the key applications that I am driving. I would probably not look at a very broad brush. That is one thing. Broadness versus focused, narrow approach to developing IP. That's one thing. And the second thing that I would do is, once I focus on a particular area, I would definitely look at what competition is doing, what competitors are doing, right? And when I'm specifically building a portfolio, I would look at patents and claims wherein the patent description and the claims would have language which is the terms would be much broader on one hand, and also I would like to choose terms which would read very closely on what the competitors are using. So if I use my patent for patent in a litigation, it is very easy to do the claim charting. So that is one thing that definitely I would keep in mind while building portfolios. Rather than going broad brush, I would do a focused, narrow, pick few things which are really important to me. For example, I would pick AI applications in autonomous driving. Right? I would pick AI applications for video processing, for example. So I would go as narrow as that to build a portfolio.
Irfan, how does IBM look at building its portfolio in addition to Watson?
For obvious reasons, I can't divulge specific strategies, but from a very broader perspective, seconding to what SK said, I believe we are in a dark spot now, wherein we don't have enough data to make an intelligent decision as to how the portfolio of AI should evolve so that it is, so that it serves its purpose both from defensive and offensive purposes. The technology, although, like SK said, although it has been very old, but it's being recently developed. We haven't seen any traction in the market or haven't heard any big ticket litigations or big ticket licensing deals specifically focused on AI. So, with that in mind and with SK's advice about being, broad and narrow at the same time, probably, that's a good idea to start with.
Anything else?
What I would recommend is that what we find is that now in the process of building portfolios, the research team is getting actively involved, and with AI-powered systems available now, and natural language processing-based systems available now, I think people are able to see what kind of applications are already being filed, what kind of claims are being made in these areas, and therefore, get more involved along with the IP team in formulating those. So I think that's one of the critical things while developing the portfolio as well, is to identify the newer areas that may not be part of the existing focus for the company.
Now let's shift a little bit to monetizing AI. And one of the challenges that we face at Wipro is when we approach a customer to leverage our platform, we get this question, well, we're giving you data, and because we're giving you data, it's going to improve your product, and therefore there's this sense of entitlement that they should own something out of it. Are you running into these types of situations? Maybe Irfan, is that also a challenge for IBM as well?
Yes, most often. It's a chicken and egg situation, like, you are giving me data, but I am giving you a product. Your data is nothing without my product is nothing without your data. So who owns whatever is the result of data? Whatever is the result of the combination of my product and your data. So, this is a situation which is, I think that, this is because of the ignorance both on the part of the product owner and the data owner. Eventually, one should recognize that, in order for the industry to grow, the service provider has a bigger role in improving the AI product. Now, if you say that you give me your data, but you cannot use the the improvement in my product because of the usage of my data, we are probably being too exclusive, and I know most data owners will disagree with me on that, but you will agree with me on that if everybody starts doing that, where do we go from here? The innovation simply stops, because artificial intelligence is nothing without data. Unless you don't have data, you can't improve your product, and if I can't improve my product, we come at a standstill. So yeah, that's a very
I think that there's an unrealistic expectation from the data owners, but it's also pressure that they've been told, get as much IP as you can, and I think that creates this sort of battle line.
Yes.
And what are some of the ways that you've been able to convince them that their data can be used to improve your product? And are there revenue share models? Are there other ways that you can work through it?
We typically, start with educating the client that, this is why it is important for us to improve the product. We also say that we will destroy your data, we will not use your data after the project is finished. Probably that is one of the ways we can try and convince. But if the ask is simply to own the improvement, and the objective behind it is exclusivity, then it's a business to business, case to case decision. I believe what every company will take. But yeah.
And your point about destroying data sort of goes back to SK's point in the beginning about the integrity of the data, the security of the data. So I suppose providing those assurances can help also having more cooperation. I mean, is that sort of what you see SK as a good marketing tool as well, to be able to show this?
Yeah. To start with, if somebody is already owning the data, as you rightly said, they think that they are more entitled to the outcome, or they are entitled to this thought that my data is improving your product. Right? If we add some more complexity to this, right? Let us say I developed an AI platform, and I go to, for example, Toyota. Toyota cars for autonomous driving use this platform. And the self-driven car is playing on the road. There is lots of data generated while it is playing on the car. Who owns the data itself is a big question, right? Because whoever owns this data, at least at this point in time, we think that, okay, data is the new oil or the new gold. From that perspective, it becomes even more complicated, because to start with, Toyota did not own the data, or I did not own the data. But when these things came together and when it started working, it started collecting more data and improving. Over a period of time, the data set that was initially collected keeps improving. So who owns the IP for that, or who has the ownership of that? When we reach that point, probably data and revenue sharing could be a good model to go forward. Dividing, I would not say dividing. We could look at applications where, for example, if this entire system of AI platform and this Toyota car is playing on the road, and it gathers the information on potholes, right? And I give it to municipality so that municipality can use it. And when I'm selling this data, or when I'm providing this data to municipality, I'm already monetizing it. Should it be based on data? Revenue sharing model is something that we need to discuss through contracts. Mm-hmm. So definitely, yes. Data to start with. We need to convince, we need to tell them it is. One thing that we need to probably acknowledge is it is interdependent. Nobody is independent here. It is interdependence.
So as they say, data is the new oil. So as they say, if it's free, you are the product, right? So I think going forward, what we are moving towards is this two-tier kind of an approach where if the user is okay with with their data being reused by a system, then you're in a situation where it will be highly subsidized use case of the scenario. However, if you want to, you are in a situation where if the data cannot be reused, then you've got to pay higher. There will be a beeline, and this is again something which I'm saying on the base of experience. There will be a beeline of of software folks, development situations where if the customer is expressly waiving the rights for the reuse, towards the reuse of that data under the prevalent regulations, or reprocessing of the data as per the prevalent regulations, you are, there will be still a huge business model which will support that use case. So that's what I feel.
Okay. So let's take a deeper dive in AI and how that has impacted the practice of law and the IP practice. And maybe, Collin, you have some experiences of how AI has changed the ability to search, a lot of benefits and time benefits, right, related to AI.
Yeah, that's right. But I should, I don't want to say that AI is new, because it's not. We have papers going back. But the application and the way it's used, and those uses are new. So let's take a simple example of patent searching. All this while, Boolean has been the choice of people to search, right? So when we came up with a AI-based system to patent searching, okay, we are very excited because it's AI powered, AI driven, and a new way of searching in a natural language way. But when we launched the product, we were just not having the acceptance. Okay, and preferably what we found is that patent searchers have developed a certain trust with the Boolean system. Therefore, to trust the AI system, it takes a little while. And we were actually compelled to develop a hybrid system of Boolean and AI together, so that we are kind of acceptable. And now, over a period of years, what we are seeing is that when they are now able to evaluate a Boolean search versus an AI search and see the quality of results and difference, there is a lot more acceptance. So I think the trustworthiness and credibility becomes extremely important. Though we all know that AI-based systems, really help us, and they are an answer for sifting to voluminous information, cost and quality of results. But trustworthiness is extremely an important element while we are looking at using AI to solve problems that we have.
What are some of the things you've seen here in India?
So I think one thing that I've been I like to mirror what Collin said, but one thing what I've been seeing is that going forward, the first pass of everything is likely to be automated. So you can choose any aspect of any situation of life, and patent drafting is not different, or practice of law is not different. The first pass is something that you've got to ride on, and then progressing further, even your, right from, what the insights that you get from data which is out there, to suggestions that you get in terms of drafting of the first claim, to suggestions that you get in terms of what's out there, as Collin said, or as XLPAT also does, to machine learning in terms of alternate use cases of words which are out there. For example, suggesting alternate use cases of any concept or word which is out there, which you ordinarily might not need. You will have to ride that. You will have to ride the wave of using a machine, or using machine towards your client counseling. So there will be two, like in the age of computers, there were two have-nots. One were computer literates, the other were computer illiterates. Probably going forward, there will be those folks who, were riding the wave and learning newer skills and skilling, reskilling, etc. And then those folks that probably were saying that, hey, this is not going to change my life. What is it? It doesn't make sense. It doesn't make sense. And eventually, you know what? You didn't keep up, and stuff happened. So yeah. And secondly, I'm one with Collin in as far as this black box kind of a situation is concerned. when you're riding and taking decisions that might have an impact on a huge amount of cash moving from one side of the table to another, you cannot rely on black box approaches. So those you've got to really have back-end systems, and also what exactly did the AI do, and also AI has got to make user its best friend. So the human and the machine needs to kind of work together, and when you're actually building systems or building your practice, you work together with the machine and then make it happen. It's almost like Siri, right? You're working with the machine all day to negotiate your day. More informed decisions, more to the point, better quality of patents, hopefully, fingers crossed, and no black box, and then first pass of everything needs to be done by the machine.
My wish list is, on a lighter note, my wish list is an AI-based judicial system, which will be much faster. You put your cases in an AI-based system, and there is an AI-based judge.
Well, nice wish, might to say. Of course, at patent offices, we're always looking and following closing alternative methods to improve, and artificial intelligence in its broadest sense has been used in patent searches for a long time, but it has been used to assist patent search in a certain way. The experience so far we are still have to go a long way if you want to replace a serious search for patent prior art, like for a search report, by just feeding the invention into a machine and getting out a search report. This, I think, we still can dream of, can continue to dream, and without dreams we will never come to the point, but we are still far away of it. We use it for sorting, for clustering, for eliminating certain purposes, but the certain final level, I always say, is not artificial intelligence, it's still human stupidity.
Are there...
I have...
Go ahead.
Yeah, so when you say we are far away, I'll just say we are a little away, not far away. There have been use cases where, as I pointed out, client counseling, for example, it's not a perfect world, but when it comes to client counseling, and in comes an inventor who says, hey, I've got this something which has never been done before, at least on a first pass, if you're able to show 5 or 6 things which have been done, and you know what is the larger state of the art which is out there, that's when you make a difference. Otherwise, traditionally innovations would take between 3 to 6 months for them to come in. When you're actually making a difference on the ground, that's when step by step those adaptions by large organizations, by the Indian Patent Office has got this technology tender out there, right? The USPTO has got a big event coming up on the 31st if the shutdown doesn't affect it too much. But these changes are happening at the ground level in the society. So I would beg to differ in saying that the traditional way of saying is far away. We might not be very far away. It might be about 6 months, it might be a year, it might be 2 years. And it will not eliminate the patent searcher positions or whatever, but there'll be a big, there'll have to be adaptation, changes, like in every other field, especially in this field because it's big data.
I agree to a certain extent with you. We have also to see what we understand from research. Do you understand from research you find about one good document, then I agree with you. We are very far with natural language processing machines, and I agree with you. However, when you speak about a structured, complete search which is reliable, which is comparable, which fulfills ISO 9000 whatever certification requirements, so you know what you have done, then then we have to go still a step with it. But what I agree with you, to find a good starting document, an entry document, or when you say you are a patent attorney and there comes an inventor and you just type in something there, here you see this exists, goodbye. I agree. There we are much closer to it, but at the very end, I think there's still time to go, and we made this comparison, and also I think we have at the European Patent Office, and we had the dream that we once can be much more efficient than we are right now with more intensive use of artificial intelligence, but we still stuck at levels of doing proper classifications to the very sophisticated end. This is something which artificial intelligence cannot do right now. That's unfortunate, a matter of fact still.
So I have a two-part question now. Are there changes in law and regulation that you would like to see in order to facilitate the growth of AI, both the protection of AI and promoting the commercialization of AI? What are some of the regulatory or legal changes that could benefit this?
So I can
Sure.
So I think this a big change or a big democratization is needed in data. I mean, without naming the company, but at least we use maps, right? We use our phones supply data. We use translation. We use like natural language understanding. We use speech context. We use cameras, right? All this data goes to a handful of companies. So when an innovation comes in, it's essentially a new form of colonialism, right? I would say that, because the data is because of somebody being early to the game, the data is so concentrated with a few companies that if that other ideas that might come in may be obfuscated because somebody else has all these large sets of data. So at some point, democratization of data, which is already a part of some data banks, is something that might be very helpful in being done. So data for good.
Though the flip side from the data owner is it comes at a cost to compile that data, right? So how do you compensate? If you're going to democratize it, you also have to compensate.
It also, that model needs to be, it's almost like these patent pools, right? There needs to be some form of a FRAND licensing which applies onto data sets as well, where at least, if there has been user data which has been with certain companies or certain, in the absence of regulation in heydays, right? For example, when Facebook started, there was just no regulation around it. It was just so new. All these years of collecting data, and now somebody else wants to come up with a technology without that data being enriched or being able to be shared. It's just nothing. So there's colonial. I mean, there's like.
But it goes back to that question we saw earlier: is that the data owners, are fighting for as much interests and rights and compensation as they can get, right? So it's going to be a challenge, I think. Any other changes and that you would see?
When it comes to AI, more than IP, I would think about developing a legal framework which is based on ethics. We have examples, right? There was a voice assistant which said, "Go kill your foster parents." That instruction was given to a child, or that was the conversation that this AI-based voice assistant advised the child. If the child were to be too addicted or too dependent on the voice assistant, without application of mind, it could have done it, right? So from that perspective, even before we tackle the IP issues, I would think that there should be a framework, legal framework for.
Yeah, and there's no universality of this yet,
Yeah.
right? Just like an autonomous vehicle, right? It sees a tree and it sees a human on the sidewalk, right? And which one is it programmed or will think of hitting first?
Exactly,
Right?
yeah.
Under what conditions, right?
What conditions?
You kill the 4 occupants of the vehicle, or you kill the pedestrian and everyone lives in the vehicle, right?
That is
ethical questions that.
Ethical questions are probably more important because if we don't address it, it can lead to huge damages, dangerous consequences. And also, I would, for legal fraternity, this is what I would think. This is what I really think so. Most of the times almost all the time, we believe that, okay, technology is taking the lead and technology is progressing, then we'll think about what the legal systems could be. But probably here is a situation or here is an opportunity for legal professionals to step ahead of technology and build a framework. Okay, you're developing technology, which is fine, but can you build it within this framework so that it is based on ethics and morality?
Collin.
I think being the standardization organization that we work with, what we've realized is that AI is going to be an enabling technologies for many different areas. In fact, the 4th industrial revolution, all of cyber-physical systems are going to be, questioning the way in which, we look at IP. I mean, earlier it was more driven by economic benefit, but I think more and more now it is the human well-being. Okay, I think that's the call we need to take, and IEEE has created a working group of, and have created a P7000 standards family, which basically look at, setting up principles in designing the AI, applications. And I think one of the most important things is the ethical consideration, within those, related to probably the, fake news, okay, or related to, data privacy laws in terms of how, consent of a person is taken. And also there are some recommendation made in the last meeting that happened. There are recommendation made on the electronic personhood, versus a corporate personhood. So there are some recommendations which are being made by this committee. So we are working towards, creating an ecosystem where all stakeholders like, people around me on the panel, Intel, IBM and others who are in this area of developing AI applications, look at these principles that are, and agree on those principles as they advance the field of AI.
And also one more area that I would think needs a lot of work is security. Encryption, security, cyber, cryptography. This is another area wherein there needs to be huge amounts of development that needs to happen.
And you feel it's lagging behind the development in AI,
Yeah.
significantly behind.
Exactly.
And just also wanted to add that we've heard that data needs to be democratized, and and what are the challenges for the data providers. I mean at IEEE we own a huge amount of data, and traditionally we've been giving it through our platform on a subscription basis primarily. But now with AI systems, we've been also challenged to make more and more of our data open. So there's a lot of openness to our data. Okay, and also open our systems. So now a lot of companies can actually log into our APIs, make calls, and design their own systems. And we are working on the licensing and contracting terms as to how this needs to be worked upon. But there is a pressure to open, and we are all looking at ways and means in which we can make business, economic, and human well-being sense from that data.
So I'd like to open the floor to questions, and I'll start with the first question. So on the flip side of what I asked earlier, what you would like to see in terms of regulatory changes, what regulatory changes may occur or political interventions may occur if AI becomes too successful where it starts replacing rather than augmenting the capabilities, and in some jurisdictions that could, translate into political intervention, things that may slow the progress of AI, the applications of AI. So how do you foresee the future? Is AI a threat, or is it something that can grow symbiotically with today's economy?
If you look at what's happening in India at a very macro level, world over we were talking about self-driven cars, autonomous driving, but when it came to India, the government's position was very clear. We will not adopt autonomous driving. We don't need self-driven cars here. What we need is an intelligent driving system which would bring down the casualties, bring down the accidents. Probably that was a mid-path where the driver safety and the passenger safety was taken into consideration, and also on the other hand, government was contemplating that, okay, if I have self-driven cars, there will be loss of jobs, which is critical for any government to stay in power or come back to power, all those things, right? And also, when it comes to a focus of how do I use AI in this country, there is a lot of focus on agriculture, health. So they are kind of compartmentalizing. And because of that compartmentalization, AI in one area can be looked at more favorably as compared to some other area. Because of which, the ability to invent or ability to protect inventions in that particular area which is less favorable could be impacted to some extent at least.
Just quickly, Irfan. So IBM has leveraged its Watson technology across many, many countries with different political systems, different economic systems. Do you foresee some challenges in terms of jobs, the potential that Watson can, be a job killer? How do you face that challenge?
The answer to this question is more of academic than practical as of today. What I personally feel is that yes, AI will impact jobs, but it will shift the nature of jobs. Because AI will do things which you were doing it manually till now. The result of that would be that you will require more people to leverage or to exploit the result of that artificial intelligence results you have got. For example, one crude example is today, if you were to chase, potential customers, you're going to call them individually and ask them whether, they need this product or not. But with AI coming in, with lots of data, you will get a list of potential specific interesting customers, and so your budget on marketing will reduce from that part, and you will need to redeploy the resources in getting those customers and giving them the best experience. Just a very basic crude example, but I believe that net there wouldn't be any job losses, but there'll be shifting in the job dynamics, and eventually it will be better for the race of humanity.
So in the valley, there are 8 jobs for a single developer in blockchain, about 12 jobs for a single developer in AI. I mean, it keeps changing, but that's the larger sense. However, if you look at the country itself, the US itself, there is a shutdown, right? So what is going on is the curse of the working class, right? Curse of the have-nots. Net, the number of jobs might remain same, but there will be have-nots created. That's why it's very important to have AI for good, AI for social good. There needs to be reskilling. There needs to be probably more and more support that needs to be provided for more technology-enabled systems. I'll give you another example. There's an organization that represents patent searchers. It's primarily a US-based organization. I have some exposure to that. I've been a part of the membership committee there. So what you attend those sessions and you don't find anybody under the age of 45 there, right? What's happened is certain jobs went away and the fresh folks just didn't join those organizations, right? So the reskilling, globalization, and also not keeping up with technologies, or the systems not reaching everybody so that they could reskill themselves for a modern system, will lead to disruption and eventually might hinder the progress of adaptation of technologies which might otherwise be good for the economy. I mean, the world's number one as well as number three economies, both of them are right now reeling. I'm talking of Britain with Brexit and the US with shutdown, and I call this the curse of the working classes, right? People who've not been, who were have-nots and were left behind. So that might be replicated when it comes to AI. It needs to be, the action needs to be taken now. We see it ourselves.
Questions? We have a microphone here.
Hi, my name is Sumer. I work for Dolcera. So I wanted to know more on the lines of what Dr. Murthy was talking about in terms of the data security. Explain what's in my mind. So with so much data being generated, and I guess the onus is a lot on the players that, let's say, either store or have generated this data. And because AI has enabled discovering information much easier, there is possibility of, for example, discovering useful information from a large corpus of, pattern information or any such sort of information out there. And there's also a possibility that AI would help discover sensitive information very easily. I mean, data is getting much structured, easy to find in that sense. So, is there a concern, for example, in large companies that own or produce this data? For example, I'd like to also know about from Wipro's perspective, maybe IBM's perspective as well, as to what is being done to, quote unquote, a lot of companies would say, we don't store your data, but when somebody would, get it out in public and say, hey, here's what you have, what are companies doing to make sure that AI does not disrupt their business model vis-a-vis the data that they use to make a business model is secure? And is there a fair, and if there is, what are companies doing?
I would say at least the companies who are at the leading edge, they are not afraid of AI in the first place. They want to take advantage of the developments in AI and develop products which would cater to that market. So from that perspective, AI is a revolution, welcome revolution for all the companies, including many of the companies here, right? From a security perspective, internally within an organization, in addition to cryptography technologies, there are also several regulations, several rules, policies. So I would think the information that is collected by a company is definitely secure, because the obligation on me to secure the data or to keep the data secured is very high. So I think there are reasonable techniques to keep it secure. My comment when it comes to cybersecurity and cryptography was because of this. If you look at the data protection bill in India, it says that data mirroring should be done. So the data has to be stored in the country. Irrespective of whoever the collector is, whoever collects the data, it could be a private party, a company, or the government. Let's say government collects huge amounts of data, and if the government does not have sufficient or enough techniques to secure that data, and if there is a data leak, then that could be hugely dangerous for the entire populace, right? So from that perspective, having data mirroring in your data protection bill is one thing, but after you collect the data, how do you securely store it is another thing. So if you are not able to securely store it, then data mirroring is a failure. The very purpose that you started data mirroring, the rationale behind data mirroring itself is flawed, right? Is defeated. So from that perspective, I was saying in this country and probably in many other countries, developing skills around cryptography, cyber security is really important. That was the context.
Right. So you also mentioned not enough is being done as yet.
Yeah.
I mean, let's not talk from the perspective for one moment of India, but generally from the perspective of large corporations. So my question wasn't that is there a fair, I know there isn't, it's a business model, but what is not being done, or rather what should be done more to make sure that, accidents like Cambridge Analytica and, I don't know, in the past, Ashley Madison and so on, don't happen again?
Yeah. I really don't have a prescriptive answer for this, but I would definitely acknowledge that, or I would definitely identify that there, irrespective of all the things that we talk about, the level of sophistication that we talk about, there were data leaks, right? There were data leaks, which means that the security systems, there is huge scope for improvement in the security systems. So I was pointing to that. I really don't have an idea of where to go from here, where should I go from here, right?
Other questions? We have time for one more. Okay.
Hi. Am I audible? Yeah. My question is, when AI commits a crime, will the software be held itself liable for it? For example, in Switzerland, very recently a robot shopped some illicit substances from online, and even Facebook also has developed AI where it itself can create algorithms or even non-human language by itself. So whom should be held liable for these kind of crimes when AI commits it?
That's a tough question because there's so
Actually,
many...
it's not a tough question if you look at for a student of law. It is the negligence. I'm talking from an Indian context, right? The negligence in developing a system. It's almost like when you're in a mall. The mall is not fire safe. Who's liable if somebody dies inside the mall, and some people are watching a movie and there's a fire and somebody dies, right? It's probably similar. So the way you are creating the algorithm and then you're connecting it to a device which might cause death and destruction, you're liable under you would be deemed liable under most laws as under the Rash and Negligent Act. This is the 304 set of sections legally. In criminal jurisprudence. In civil jurisprudence, you would also be liable for eventually being tried under lawsuit under the Civil Procedure Code and so on and so forth. So the liability is strict in as far as in common law tortious liability. It's called the principle of strict liability. That would apply to a system or a software which is developed, which might be integrated with a device, and that might cause death and destruction, or even in cyber law that might create. It's probably so far till a special law is enacted, this general law which adequately covers these scenarios would still apply.
From a U.S. perspective, you would have products liability and you would have negligence. So from a products liability liability standpoint, either it has a defective design, defective manufacturer, or you failed to warn. Strict liability would come in only if it was inherently risky, so if that tool was used in the operation of a nuclear power plant or for a vital system in an aircraft, right? But yes, you would find, some way to get liability in. All right. Do we have time for one quick question, if your question is quick. All the way in the back, please.
Yeah, hi. I represent Sagacious IP, the ICT division. My question is more in terms of how AI is, we have been talking about AI, the whole field as such, the ethicalities about the data, but if we tie the field AI to, say, the actual IP that we are taking, so if we tie AI to patents, then what are the best practices, keeping in mind, say, Alice and Fish and Mayo, of drafting patents towards AI, translating your technical knowledge in terms of patents?
So my question is, did you have a late lunch? So the first part, I think, was exactly the discussion that...
Because we had that in the beginning of the discussion, we talked about patentability.
So maybe you can go through I think this is being recorded or something, you could go through those tapes, unless you want to repeat something.
Okay, thank you very much. Please say thank you to our distinguished panel. And you're welcome to ask some questions after this event. So thank you again.